I believe it was called Sex, Lies, and Damaged Lives. And I think, that's been the picture that has been painted here. This case is about two damaged individuals who somehow found each other, fell in love, a mad, passionate love, and then together they became extraordinarily marketable, which in turn fed upon their love and need for each other. But before I go and discuss that, are you ready for the spoiler alert? Okay? Are you ready for the spoiler alert? We are intending upon conceding a fair amount of counts. And when I get to them, I will explain to you why we're conceding them, and you can go right back there, and in terms of those counts, you can check the guilty box. It may not be the top guilty box, the guilty of the full completed crime. It may be one of the lessers, but nonetheless, we will be conceding crimes. And the reason for that is John wants to take responsibility for the crimes for which he is guilty.
Judge, I'm going to object to that comment in regards to we need to approach.
Okay, come on.
And then before, okay, proceed. Thank you. And then before we move on, I wanted to make one further point, which is that this is not a case of John versus Christie. This is the state of Nevada versus John Copenhagen. This is the government of Nevada versus John Copenhagen. So, one of the most shocking things in this case is up until and almost including the time of the events on August 8th, we have those texts from Ms. McInday, which is misspelled. Apologies. They said they were going to see each other tomorrow. John told her he was skipping the fights. Right? You should skip the fights and come here. And she asked what time he would get there, and he said 6 to 7. That is undifferentiated. He did not say 6 p.m. to 7 p.m. He said 6 to 7. And of course, the language. I want to wake you up with my tongue in your pee, and that was fine with her. And forgive me if I don't repeat all the language. She knew he was coming. And she knew he was coming soon. And more than that, she told you that she was damaged. She explained to Corey, and those texts are in evidence, to Mr. Thomas, those texts are in evidence. And how do we know that she's damaged? Other than that, her texting conversations with John the day before what we've referred to as the big incident, she knew he was coming. And she knew he had a special surprise for her. And what exactly was her plan if he was coming at 6 a.m.? To kick Corey out at 5 when they had materials to unload at a convention starting at 3? If she believed the police were coming, she could have slipped right out that back door. If she had any thought that Mr. Copenhagen was going to be violent with her. But she stood there and she watched the fight between Mr. Thomas and Mr. Copenhagen. It leads to the inference that she believed that he would not be violent with her, which is the further inference that he had not been violent with her in the past. And one of the things, and one of the more important things that came out in this trial was Ms. Erin McAday talking about how they're getting into a verbal dispute, and John's trying to pack his materials, and he's screaming, "I'm going to kill you, I'm going to kill you," while packing his stuff. And she had to stop Christy from continuing to fight with John. So one of the critical questions, why not run and hide? If the police are coming, you know, even if you leave the phone, you take the phone, whatever you do. If John truly had this history, you don't just stay there. She was watching the fight, cage side. Cage side. And here we go with some of these. August 7th, 2014, or, you know, this is about, what, 3 hours and 10 minutes before the incidents of August 8th. And by the way, 22 minutes before Corey Thomas got there, she's sending this picture of her in the tub. And then 10 minutes later, or rather 12 minutes before Corey Thomas got there, she's sending him this one. So that's her damage. And then there's John's damage, which is a lot. And it's much more than the bandaged brain there. It's the Lexapro, it's the Adderall, and it's the steroids principally. And we'll talk about this a little bit more, but we'll talk about the drugs in relation to defenses to a specific intent crime. We use the language that they negate specific intent, meaning he wasn't, based on, for example, the roid rage, wasn't able to form the intent to some of these crimes. And then what you have when you have these two people together is the heat of passion that explodes. Now, before we get too deep into this, I wanted to talk to you about what, some of the exercises we did in board here. And I forget who I picked on, but I apologize to you again. If you're still here. I don't remember. But Frankenstein was the name of the doctor, not the monster. And that's one of the things that, almost everyone gets wrong. And it's just one of those things. We grew up believing Pluto was a planet. And now it's not. There are certain things we knew to be truths that are disproven. If Stephen Hawking's theories can be disproved, I think you need to have an open mind to this case. So one of the things that's important and that we talked about is this concept of mens rea. And it was put into effect by the founding fathers of the Constitution. And we talked about, or you were instructed about, two different types of mens rea, or mens rea, depending how you like to pronounce it. And one of them is called general intent, and one of them is called specific intent. And those are defined for you, and the crimes that match those are delineated. And there has to be a union of the act and the mindset that needs to be present with that act, be it specific or general intent. It doesn't work any other way. And mens rea can be negated in specific intent crimes by voluntary intoxication. Now, there's a lot of testimony in this case about an unusual relationship, especially inside the bedroom. But even outside, this is not your typical. This is just not your typical pairing. And you have to think about criminal versus immoral. And these are fine concepts that need to be construed. And just think about the fact that immoral is not criminal. Whatever you think about cheating, cheating on a girlfriend, or maybe deviant sex, or what have you, that's not charged here, and that's not something that should be judged against Mr. Copenhaver. Keep in mind also that not guilty does not mean innocent. It means not proven. Government has to prove every element beyond a reasonable doubt for you to return a verdict of guilty. Unless and until that point, Mr. Copenhaver is entitled to a verdict of not guilty. So there are different duties by different actors in this case. The police investigate the crime, they deliver it for charges, but the jury is the judge of the facts as they apply to the law. And flatly, it's an interesting case in terms of the police because they were some of our best witnesses. Detective Tomino went over the same report, went over Detective Lafreniere's report, and all of them said, were you sexually assaulted? No. Was there past sexual assault? No. But yet they determined that there was penetration, however slight, inside the labia majora, or these so-called big lips. They were fantastic witnesses for us. We are not attacking the police. So let me talk about the roadmap. We're going to talk about criminal law fundamentals right now, some of the basics, how you take the law and apply it to the facts, and then what the facts truly are in this case. And I'll try not to take a day and a half describing it. All right, so if only she had built a smaller house, and by that I'm discussing the charges in this case. The DA bears the entire burden of proof. She has to prove to you beyond a reasonable doubt every crime and every element of every crime. And we believe she made a mistake in charging. This is a kitchen sink case. There are 26 counts on Ms. Mack alone. 27. Almost half of those do not arise from the August 8th incident, and do not arise from those horrible and graphic pictures, and I'm going to talk about that later. So, why do that? Because we would suggest, are a number of defenses to these crimes that we'll get into, and some will stick. And that's why you charge 34 counts. And on every count, we do not concede. If you feel the evidence bears it, you are entitled to return a verdict of not guilty. Indeed, you're entitled to return a verdict of not guilty on the counts that we do concede if you disagree with me. And don't forget, Mr. Copenhaver walked in, well, didn't walk in, but Mr. Copenhaver started this case with 7 counts. And here you sit, charged with the task of determining 34. Big difference. So there was a jury instruction that said there is no requirement that the testimony of a victim of sexual assault be corroborated, and her testimony standing alone is sufficient. But that does not absolve the state from having their burden of proof. The judge has told you what must be proven in terms of each count and each element of each count. And each one, and I know I just said this before, but this one has a cute little graphic, has to be proven beyond a reasonable doubt in order for there to be a verdict of guilty on it. And in terms of reasonable doubt, the state has the burden of proof. And the term for reasonable doubt is abiding conviction. You can think of it as a lasting relief, lasting belief. We produced evidence in this case. We called witnesses. That doesn't mean that this case shouldn't have to rise and fall alone on the prosecution's evidence. You can completely ignore the entire defense case and still find Mr. Copenhaver not guilty because you feel that the prosecution hasn't proved their side of the case. That's what we call burden shifting if you take it upon Mr. Copenhaver to prove his innocence. It's not what you have in the law. The burden of proof, and it's a heavy burden of proof, rests squarely on the shoulders of the prosecution. Okay, let's talk about reasonable doubt. It is the highest standard in the law. These aren't quantifiable, but probable cause is the standard for issuing a warrant. Preponderance is the standard to prevail in a civil case. And preponderance actually can be quantified. It's anything over 50%. So, take 50 point, 100 zeros and then, 1. It's over 50%. You have proven your civil case by a preponderance. Clear and convincing evidence is the standard in Nevada by which you can remove a child from a home. And then above that, although below that in the slide, but above that is the lofty standard of beyond a reasonable doubt. And there's a puppy up there because if you lower the burden on beyond a reasonable doubt, you make puppies cry. That was a joke. Come on. So my wife has a story, something that is helpful in terms of understanding the liberty interest in a reasonable doubt case. And it's, think of these words, steep, thick, and asymmetrical. And a couple of years back, she had LASIK surgery on her eyes. And before the doctor would operate, he had to be sure that she didn't have particular corneal conditions. Otherwise, you can go blind if you do those LASIK surgeries. So there are 3 signs that a person has this condition. It's called steep corneas, thick corneas, and asymmetrical corneas. And her corneas might have been steep. On the first pass through, the doctor wasn't sure. That's a reasonable doubt. The doctor redid it and the doctor sent her out for a second opinion. And still there was reasonable doubt. And then on the third opinion, there was the surgery. So the first 2, if you're in that zone, that's reasonable doubt. If you're just a little not sure.
Judge, I'm going to object as to the quantification of reasonable doubt. It's actually what it is in the instruction.
Right. So, ladies and gentlemen, the instruction states exactly what reasonable doubt means. You can only rely on that description of what reasonable doubt means and disregard anything to the contrary.
All right. Going on. There is, obviously you didn't hear from Mr. Copenhaver in this case. There is just, human nature tells you that you want to hear from the defendant. We talked about in voir dire any type of reasons that a defendant might not testify, but that's not germane here. The fact of the matter is he didn't. It's his privilege not to do that, and as the judge has instructed you, it's not to be considered. So, again, it's human nature to want to hear from him. It's human nature to think about it. But as jurors, you're charged to follow the law, which means you can't think about it, you can't consider it. Let's skip over this next slide. And in terms of specific intent crimes, we had Dr. Holper, or Dr. H as he likes to call himself, talking about acting reflectively, being without thought. That's a defense to specific intent crime. The animalistic behavior, the inability to control. Roid rage is a great example of that. A blind rage, tunnel vision. Think about the raging Red Bull. And then there's a discussion, there was jury instruction about the questions of counsel not being evidence. And there was discussion about the hippocampus between Ms. Bluth and Dr. Holper. That is not evidence. That is not evidence. And here we go with the expert testimony. No one on either side testifies for free. The police officers are oftentimes always professional witnesses because it's their job to do the reports and then come into court and testify. They're paid to do that, and some handsomely. Domestic violence are paid to do that. The state is paid to prosecute their case. Everyone in this is compensated. Nor are you to speculate about who paid these experts or how they will be paid or anything of that magnitude. It is beyond the purview of this case. Now we're going back to Dr. Holper. He said, Ms. Bluth, you don't know what a white lesion is. That testimony was not rebutted in any way. The state had the ability to call their own expert to explain about brain slides, to explain that maybe the reading, which by the way was from the radiologist, not Dr. Holper, and was based on more than a single slice of an MRI, why that wasn't correct. They failed to do so. Now, let's talk about this domestic violence expert. Here's, again, my silly joke about it. Is it a common domestic violence situation if the moon is aligned with Jupiter and Beethoven is on the radio? Yes, I've seen that many times. So, can you tell me if a victim having rape fantasies and that enjoys being choked unconscious during sex is common in domestic violence situations? And of course, every answer that pertained to facts related to this case, that's too specific. I just can't say. That testimony should be rejected in its entirety. It has no value in this case. Now, there was an instruction about circumstantial evidence, and that goes to a number of the witnesses in this case that don't have direct evidence, meaning they weren't there, they heard things, they saw things, but that wasn't related to they weren't present at the actual incident. So it requires proving a thought. And you have to think about how difficult it is to get inside someone's head and understand what their thought process is. And in terms of Mr. Copenhaver's mental state, the evidence is circumstantial. It is not direct. You don't have testimony that for certain he was thinking this, he was thinking that. And if you can draw multiple conclusions from that, you have that are both reasonable, even though they may be diametrically opposed, you have reasonable doubt.
Judge, I object to that. It's still the quantification of reasonable doubt.
Well, ladies and gentlemen, I've defined what reasonable doubt means for you, and you'll need to rely on that in making your determinations.
And you could draw reasonable inferences from the evidence. It's not based on speculation or guesswork. Now we'll go over these one by one in just a little bit, but when tied to the presumption of innocence, the defendant is entitled to the benefit of the doubt. I like to put it a different way. Tie goes to the runner, the baseball expression. If you feel that Ms. McInday's memory was impaired during the August 8th incident, you may find those counts not to be proven based on a lack of evidence to put the case into a posture where a guilty verdict is possible. Another thing that you have to do is where multiple acts occur as part of a similar single transaction, you can find the defendant guilty of each separate and different act, but you have to unanimously agree on each element of the crime. Now, there are instances of threats where there are no specific dates, it was unspecified, for example, on what dates and what actions there were that resulted in the taking of Ms. McInday's phone. That's ambiguous. You would have to agree on when. You would need a unanimity.
Judge, I'm going to object that misstates the law. You do not have to agree on when. That's not an element of the crime.
Come on up. All right, folks, so it's correct. The state is not required to prove the exact day or time that the incident happened. It's not an element of the offense. Go on.
Okay. All right, we're moving along here. So let's go over what it is in this case that constitutes voluntary intoxication. Oh, great, I spelled Adderall wrong. Adderall, that's what Dr. Holper testified to was speed. That wasn't, from any evidence we have here, wasn't taken for ADHD. Lexapro, which is the antidepressant, which could be a correct or incorrect dose. There's actually texts in evidence where Ms. McInday says to Mr. Copenhaver, hey, look, either get off all the drugs you're on or get on more. And there you go with respect to the Lexapro. Now you have the testosterone, the roid rage, the swings, the increased libido, the need to have sex 3 times a day. You know, that adds up to voluntary intoxication. Not in a classic sense. This isn't someone who went out and took, you know, methamphetamine or alcohol or heroin or what have you. But nonetheless, this is voluntary intoxication. Now, when you add this to rage and sudden shocking events, you really have quite an explosive situation where someone loses their mind. Now, I want to talk about some red herrings. I'm getting into the elements of the discussion of the crimes really soon. I want to talk about some red herrings. So, if you remember an opening, it was, suggested, the horror of throwing a dog blanket on her, like it was to demean Ms. McInday. And the evidence came out really clear. Mr. Copenhaver, during the supposed 2-hour beating, felt that she was cold and put the blanket on her. And she still has that blanket on in the hospital. She's still clinging to it. And she loves her dogs, and she testified that every blanket in that house is a dog blanket. She said 18 broken bones. That's not true. I believe the ER doctor testified to 4. Testified to broken ribs. Not correct. This supposed, this Instagram post, Ms. McInday had an abortion, and it's a picture of the tattoo she got. They went into a public Twitter fight about that, and Ms. McInday agreed that was made up effectively. And then there was an insinuation made by Ms. McInday that Mr. Copenhaver was just cruel to her animals and was indiscriminately beat them. Was the impression that was intended to be left. When in fact, Ms. McInday's mother testified that no, Cleo, the bigger of the two pit bulls, went to bite him, and the hit on Cleo was discipline. There are a whole number of red herrings in this case. So you have a good deal of testimony, not a good deal, but you had testimony on Friday from Joshua Ibarra and Francesca, I'm sorry, not Ibarra, but they identify as husband and wife. She showed up at the Christmas party with, well, one said a welt, one said a cut, but either way with some degree of damage, and I think they both said head. First of all, what family Christmas party do you have that you don't snap at least 1 or 2 pictures? These are the events. These are the events of your life. Having your family around the table for Christmas. There's no pictures from December 25th. Okay, here's December 20th. No damage. And next in order, December 31st. Happy New Year. Where is it? Where is it? It's a good inference from these 2 pictures that it didn't exist. And if it did, there would be a picture of it on Christmas, and there is not. And now that leads us to this secret folder. And you heard from Mr. Burgess, and you heard from, who has tons of training and 35 years of experience, and you heard from Johnny Rockmore. And while I love his name, Johnny Rockmore, he isn't trained in this area, and he is not any type of expert in computer forensics. And as Mr. Burgess testified, if you sync with Google+, they stay in the cloud, notwithstanding any change in phone, even if the phone is broken. So Johnny Rockmore, so now you have this idea of a secret file with 20 or however many pictures in it. And Mr. Rockmore gives you the clue, which is this. They were up in the cloud so he could see them, so he can take them. So he noted for some reason he thinks he can identify a broken nose. Not aware of his medical training, but okay, maybe in a lay sense. But the point of the matter is that that so-called secret folder Mr. Burgess told you can be synced with the cloud nonetheless. These pictures, if they ever existed, still exist. They're up there. They're up there. And the state made no attempt to get them. They made no attempt to call an expert, to talk to Detective Flink, to figure out if they can get them. You know why? Because it's a lot better to say they exist and find out that they don't exist, than find out that they don't exist, which they don't. So, okay. I told you we'll be conceding some counts. Pardon me, I'm catching up to myself. So here may be the second easiest count you have in this case. This is the dissuading of Corey Thomas. John is hot. He's in that red zone, that roid rage. He's going bananas, right? That's the testimony. And then this is the third choke, the one that was referred to as a seatbelt, or that was asked of him about a seatbelt. And we know, by the way, these are seatbelts by the dislocated shoulder. And Mr. Thomas asks him, what's your end game? Are you going to kill me or are you going to let me go? Because I have friends that are detectives and they'll be looking for me. And Mr. Thomas says he kind of snaps out of it, which would be out of the red zone. And then he says, well, if I let you go, are you going to tell anyone? I have friends that are Hells Angels, Navy SEALs, all of that. Mr. Thomas made his promise that I have no idea. I have no doubt that he would have kept, but for his friend who has some small and old training about maxillofacial surgery saying, no man, you gotta call the cops, you gotta go to the hospital. So that's easy. That's really easy, because he's calmed down. That's not the Red Bull. That's the calm, cool, blue bull. And as you see there, that's guilty. Now I said that was the second easiest count in this case. Here's the easiest. Burglary, which is intent to commit theft or assault and battery, or any felony at the time of entry. So this would be the time of going in, right? So you remember that picture? I don't know if I have it here coming up. I don't think I do. But there's that picture that, oh, I do. So I'll get to that in just a second. So this is almost 2 o'clock in the morning. It's dark. There's a Range Rover out front. Same car, by the way, as Ms. McInday. No testimony about different colors, different models, different anything. Range Rover, same car as Ms. McInday. Parked, back down. And you see these houses are close. You've seen a number of pictures of these houses. And it's parked over here. And the idea is the state's argument was that he saw a car and charged into the house and threw open the door for a fight. All right, let's talk about that. So he had the key. Ms. McInday knew he had the key. He'd let himself in the past. And you could see from the texts, he was supposed to let himself in the next day, put his stuff away, and then go to the tattoo convention. So, all right, now you can come in, you can keep the key, but you can't surprise me? or you can't surprise me when I'm with another guy. I'm not quite sure what the rules are there. But one key thing is that John dropped his bags when he walked into that room. So, interesting thought. Don't burglars, and these are at common law, I understand the definitions are different. But you know, I'm talking about the guy in the black clothes and the black hat, the cat burglar and all that. Aren't they supposed to show up with empty bags and fill them, as opposed to their own bags of their clothes? That's your key. So, and then of course, here's the, I mean, this is the linchpin of it, and this is why the burglary count's just so easy. John enters the room expecting to get engaged and to be sucking on, waking her up, sucking on her lips. And he turns on the light and sees Mr. Thomas, and he says, as Mr. Stevens says, I don't need to elaborate on what the words are, but WTF, meaning, I'm surprised. What the heck is going on here? Once he's in the room. I can't, I mean, I'll just throw open a question for you, which is, how is that intent to enter to commit assault and battery when you're surprised by the situations in the room? This is the easiest count in the whole case. This is not guilty. I mean, this charge is easy. So let's take a tour around this room and see what we have. So you can't see it so great here, but we're going to get to it. On this side of the bed, where I'm kind of holding my hand off screen, is where Mr. Thomas was sleeping. So that's looking at it the left side of the bed. Looking at it the right side of the bed is where Ms. McInerney was sleeping. And here's the nightstand in question. It is said in evidence that Mr. Copenhaver says what? WTF. And you know, Mr. Thomas tries to sit up, and Mr. Copenhaver is on him in just a second. Now, the testimony from Ms. McInerney is a bit different. She said he stood there for about 30 seconds, screaming his head off, saying she doesn't remember what he said, and then proceeded on there. Either way, I'm not going to keep beating on the burglary, but either way, there's that thought period of, you know, why is there a guy in bed with you? And she testified they were fully clothed. Okay, you know, maybe that's a definition of fully clothed, you know, t-shirt and boxer shorts, little short shorts and a tank top, although Mr. Thomas testified that she was in sweats. Goes to an ability to perceive, an ability to remember. So Mr. Thomas kicks off with his foot and then is able to drive Mr. Copenhaver into the wall. And we'll get to a better picture of that. But you can see why he so easily does that, is because when they roll off, although they didn't test this for blood, it's really clear that Mr. Copenhaver's head hits the corner of the table. How do we know? Look at the dent and look at the blood smear here. That's positive for his blood. He didn't hit this. They weren't up. Mr. Thomas pulled him down. This is where he hit his head. That's where he bled. Okay, so you see it now. That's the nightstand, and this is his blood. And this is not, as Mr. Thomas says, from a little cut to his arm, a small cut. Not this type of blood, not this much. Oh, and by the way, what are these? In a plastic baggie? Someone who's taken pills in the past, claiming that it's from when Mr. Copenhaver beat her in December, which we've now seen pictures of before. But nonetheless, this is someone that's supposed to be straight edge. No drugs, no alcohol, and she's knocking back NyQuil, and she's taking pain pills. That's her image, is straight edge, and we've talked about image. And the image isn't an accurate portrayal of her life. And that's important, and I'll discuss that. So here you have a close-up of, and this is quite a dent where Mr. Copenhaver's back goes into. That's a good deal of blood, and you can see it was a lot of blood because it's dripping down. Now, Mr. Thomas testifies to the fact that they went to the floor and there were the 2 further chokes. But over here you see pieces of wig, and this is blood. And here is the shower. And Ms. McInday testified that she showers and she doesn't know how she gets into the shower. Yet somehow she's positive that either Mr. Copenhaver undressed her or commanded her to undress, which makes no sense that she would remember one and not the other. No sense at all. But you saw her pictures of the hospital over and over and over again. You saw those pictures, and what's all over her face? Blood. So what isn't here when she testifies she gets down on all fours on the marble, supposedly after taking a shower? Not blood. Not from I don't remember the name for the tooth. Not from the broken nose. Not from anything else. Not blood. Not blood here. Tends to indicate there was no shower. No testing of blood, and look at that. That's the knife blade. And that's supposedly hair. And this is supposedly hair. You would expect that if she's bleeding profusely, like she must have been from both the mouth and the nose, there'd be a bunch of blood. And it's just hair spewed about. Now here's the butcher's block from the kitchen. And Mr. Copenhaver supposedly goes downstairs. He switches out the broken blade for another steak knife. If he's going to kill her, which knife do you choose? If he's going to kill her with a knife, not this one, this one. And by the way, when we'll get to a close-up of this also, here's the knife, and these are the cut-up wigs. And this is her top. So let's go right into the attempted murder. Can you just give me a second to catch up with myself, please? Oh, I'm sorry, I'm going to skip past this. These are wrong. So an attempted murder is, and it's your instruction number 31, intent to commit a crime, performance of some act towards its commission, and failure to consummate its commission. This, I would submit to you, is also not a very difficult case for a not guilty. And let me explain why. There's an intent to kill versus an intent to terrify. And Mr. Copenhaver, historically, or at least historically in the time period we're familiar with, seems to wake up in the morning wanting to kill, tweeting about wanting to kill, and then tweeting about wanting to kill himself. And every morning that he does it, he doesn't kill himself. He just does it. And he said to Ms. McInday before, I'm going to kill you. And you've heard that. And he doesn't. And he's just, the words almost become meaningless. And here it is again, going back to Aaron McInday's testimony. There he is in the closet packing his things, and he's screaming, I'm going to kill you, I'm going to kill you, I'm going to kill you. And Aaron McInday is explaining that Christy McInday is still going at him. Still, I don't remember what word she used, still jawing at him. I forget, but that's what I took away from it. The I'm going to kill you is an intent to scare, and I'm not so certain that it did in all of these situations. I'm not suggesting, obviously, because it seems to be a completely different situation. But he already had a knife, and he was using it, and he poked her with it. So obviously there's no intent to kill at the beginning. He also didn't believe this was the end of their relationship. If you believe her statement that he sexually assaulted her and said, you know, this is my pee and I'm taking it back. It's hardly evidence that he intends to kill her right there. They discussed taking a vacation, hiding, maybe in San Diego or somewhere else while she heals. And then supposedly he says, I'm going to kill you, goes down and gets a knife, and we'll talk about that in a second. First of all, this picture kept getting put in by the prosecution, so why not? If this guy got Corey Thomas in a rear naked choke and really wanted to put the pressure on and really wanted to kill him, he could have done it. And if he really wanted to kill Ms. McInday, all he had to do was keep hitting her, kicking her. That's all he had to do. He doesn't need a knife. So, yeah, let's talk about this. Ms. McInday's testimony, he being Mr. Copenhaver, goes downstairs and gets a knife, and she hears him messing through the drawers, and he comes up, and she jumps the fence and runs away. Okay, so she's not there. And I guess he's thinking that, what? I guess she's out on the golf course at that point. She's probably going to play 9 holes. Or she's probably going to be getting help. Because I got to tell you, to believe the theory that Mr. Copenhaver went downstairs to get a knife and then came up to, quote unquote, finish her off, you would have to believe they got back upstairs, and instead of leaving, he went and kept cutting up wigs, because I know you probably can't see it, but Ms. McInday testified she had this silver wig, and these are silver, I think they're silver. First of all, it's not a great picture. Second of all, I'm colorblind, and I thought I remembered some purple ones. And I'm just saying that because I thought there was a purple wig. I don't really know what purple is. But they're on the night. They're on the night. So, okay, so she runs, jumps over, she's on the golf course. He goes down, gets a knife, and then he keeps cutting up the wigs, and then leaves. I just, come now. Come now. Not guilty on attempted murder of Christine McInday. Bigger knives available, we talked about this. let's talk about our memory of August 8th. So she testifies she doesn't remember almost anything except being in two different positions. One on all fours outside the shower, where you would expect there to be blood, based on the fact she shows up at the hospital with more blood. And then on her back for this supposed sexual assault. And I don't mean to be nasty about that. And I'm really not trying to call Ms. McInday a liar, because I don't honestly think she is. Let me explain what I mean by that. There's a thing, there's a natural thing that humans do, which is backfill memories. And I'm going to explain, I'm going to tell you a little story about why I say that and what I mean by that. So, some of you may know, maybe all of you may know, there was a 1960s band called the Mamas and the Papas. And the primary songwriter was Papa John Phillips. And he had apparently a hidden and very bad drug problem at that time. And the Mamas and the Papas were on tour with the Buffalo Springfield, which was if you know, like Stephen Stills from Crosby, Stills and Nash, and Neil Young. And they also had a folk singer named Judy Collins there. Crosby, Stills and Nash wrote a song about her called Sweet Judy Blue Eyes. And they're in Arizona. They've done a show in Phoenix. And they were talking about, we should write a song, a great Western song. And, you know, John Phillips, being the amazing songwriter he was, just sort of picks up a guitar, and in short order, he's written this song. And they have a tape recorder, one of those old reel-to-reels, and the song's called Me and My Uncle, and I'll get back to that in a second. And Judy Collins takes the reels, and, you know, with John Phillips' permission, and she records the song on her next album. And in the mail comes a royalty check for John Phillips. And he looks at it and he sees it's for, you know, Judy Collins' recording of Me and My Uncle. He says, you know, what's this? He says, I didn't write any song called Me and My Uncle. And you know, he's blacked out on drugs, alcohol, all of that in Phoenix. So he sends the check back, and they tell Judy Collins, and they're like, no, this is interesting. No, John Phillips wrote the song. And he said, okay, well, I'll take the checks. Of course, I'll take the checks, but I didn't write the song. And then the Grateful Dead started playing that song, and it actually became, other than their drums in space that they did every show, it actually became their most played song. And it's, I don't know if you know how many live albums they have, it's possibly somewhere in the millions at this point, but it's on so many of them. So once the Grateful Dead started playing it, boy, the royalty checks really started coming in. And John Phillips said, each time I got a royalty check, and each time the royalty check was bigger, I remembered more and more about how I wrote that song, and how we were in Phoenix, and, you know, Neil was there, and Stephen, and Judy, and, you know, it was a great time, and it was a tequila sunrise, and we were just having so much fun. And that's backfilling a memory. Everything about it made sense. He knew the story. He knew what had happened. He knew he loved the checks. And all of a sudden, his non-memory was his memory. You can get where you're going in this case without calling Christine McInday a liar. And I would suggest you do that. This is an honest, mistaken belief. She believes these things. They're not true, but she believes these things. And of course, except for the items that make Mr. Copenhaver guilty, she has almost no memory of that evening. And not only that, but when you look at her memory, she had a 3-hour exam with what Detective Tamano, or who Detective Tamano called Nurse Jerry, because apparently only Ms. Bluth can pronounce her last name. So, let's talk about count 14. This is kidnapping with a deadly. So, the kidnapping is the more than incidental, or the movement to accomplish a purpose. And we've kind of gone over these things, but this is why kidnapping is a not guilty in this case. The charges specify a knife. He had that first knife, he didn't use it. He had the second knife that he used for the wigs, didn't use it. No testimony that he went down for a third knife. So that's kidnapping with a deadly. Now there's a lesser included that you've been, meaning a charge that you, if you find the evidence proven beyond a reasonable doubt, you can find Mr. Copenhaver guilty, and that would be kidnapping, false imprisonment. And it's incredible, incredulous, inconceivable to me that nothing is remembered here, there, and everywhere, all the way up to 6:30 the next day, 3:30 to 6:30. Pardon me. The examination by Nurse Jerry, and yet these pieces that are so critical to this case are remembered. Doesn't remember how she got in the shower. We don't even know if she took a shower. Flatly, and I don't mean to be derogatory, but you saw Mr. Sue's cross of CSI or CSA Speeds. Nice fella, did a lousy job. How do you, I mean, there's no pictures from inside the shower. There's no good close-ups of the marble. Well, the reason there's no good close-ups of the marble, I would submit, is because it tends to exonerate Mr. Copenhaver. But he was aware, by the time he got there, he was aware of the general story. And it is his job to faithfully collect evidence. And, I mean, I guess it's up to you to decide. Are you satisfied with the way evidence was collected in this case? So many things missing. So many pictures I would hope that you would want to see that were not taken. There's no real evidence she took a shower. I'm sorry. So battery with the intent to commit sexual assault. And this isn't a specific intent crime, but nonetheless, John is hot. He's red.
I'm sorry, that misstates the law, that's a specific intent crime.
Oh,
I'm sorry.
I didn't.
The intent to commit the sexual assault has to be present.
Sorry, I'm crossing my wires. Thank you,
That's
Counsel.
okay.
I thank you, Your Honor. All righty. And that's, I guess, the reason I have the red ball. If he's in this hot state, this reflexive state, this roid rage, coupled with all of his other issues, and he's going in and out, as Dr. Helper can testify, it's you know, something happens and it sets him off again, and he goes red, the raging bull all over again. You have the voluntary intoxication defense to the battery with the intent to commit sexual assault. Now, you can find him not guilty on that reason alone. However, there is a better reason. DNA. The testimony was that the vaginal swabs would not be expected to have saliva in them, even though the DNA expert testified to a mixture, that there would be a mixture. She didn't find it, although she said certainly possible that it would be there. She didn't find it. And yeah, she didn't find it. Yeah, she didn't find it. Of course not, because it wasn't there. I mean, it was made out as though the only portion that was swabbed was inside the lips. That was how she tried to color the testimony. However, what was the actual evidence as presented by Ms. Mack? There was a spitting in the hand and then a wiping from by the anus all the way up through. There are areas in there that aren't affected by vaginal discharge, wiping after urine. If there was DNA in there, in the swab, there were other areas it would have come from. The reason there was no DNA is because there was no saliva. Again, this isn't an issue of lying. This is an issue of backfilling memory, especially as to a traumatic event. I told you I was conceding counts, and Mr. Copenhagen was conceding counts, and we will get to that shortly. I'm not trying to take away her victimhood. I am not trying to justify the battery. But there are things that happened, and there are things that we think, and we forget about what we think, the evidence doesn't support happened. And the battery with intent to commit sexual assault is primary in that. Now there's a third issue with this charge. So you have voluntary intoxication, a lack of DNA. What else do you have? Well, you have this charming back and forth between the two of them over basically the course of their whole relationship, which is, whose pee is this? It's yours, baby. Damn right. You know, real men rape. So the statement was that Ms. Mack provides, this is my pee and I am taking it back. Pretty consistent with all their text messages over whatever it is, less than a year and a half. In the state he was in, the rage he was in, the in and out, Mr. Copenhagen well could have believed reasonably that he had consent to do so, that being his. That's a third defense to that crime. And here we go on this. It's mine. And here's the rape tweet. Just raped at Christy Mack. She tried to make me wait until after errands as if. 1:11 p.m. on the 10th of August, 2013. Just under 2 hours later, Ms. Mack, be right back, going on a rape spree. Now, I don't know that that's really who Ms. Mack is, this behavior. I really don't. But her testimony is important in this regard. And what it is and what it shows is that Mr. Copenhagen was very insecure. And he constantly needed affirmation. John, you're the biggest, you're the best, this is yours. You know, whatever it was, you know, she gave it to him. And I asked her, well, you know, something to the extent of, well, were you really, did you believe it when you said these things, or did you whatever? No, I just, you know, said them to kind of placate John. I said, did he believe them? She said, yeah. Yeah. Because her behavior was consistent with the text. Even if she didn't like it, even if she didn't want it, there was a persistent pattern of this behavior in their relationship. So here you got, pardon me, 10/8/2013, October 8th. Rapes. That's from her. Received and read. John, real men does. You're a real man. This may have been a joke to her or her playing around. She testified. This fellow, John Copenhagen, he believed this. And that's what's important. It's not about actual consent. It's about a reasonable belief in consent. Here's another one. These people are just different. It's not bad. I don't care what they do behind closed doors. I hope you don't either. But it's different, and it's important to understand. Christy, you can fuck who you want. I just want to know, and I want you to answer all of my questions. I think it's pretty fair. First of all, it speaks to his libido on testosterone. Second of all, it speaks to, it speaks to him and what, you know, he was entitled to do in this relationship with Flatley was almost anything. I guess it's set make her look bad in front of other porn stars, which she testified to. So here's another one, and these are the ones that are really, I'll glance it quickly. So here's 1037, 38, and 39, Sexy Mr. Machine. This is the picture, 2237 is the one in the bathtub. John, I needs that from Christy. It's all yours. Right before the supposed shower rape. Right before the incidents of August 8th. I don't know what you think he's supposed to think at this point. And what he thinks and what he believes is critical to these rape charges. So here we go on this. A reasonable belief in consent. I'm sorry, this is very small. Christy test. So we talked about this. Said did things to placate John and you believed him. My gosh, apologize. So this is August 7th, 2252. 8 minutes before Corey Thomas got there. John texting her. I can't wait to suck on your meaty pee. I crave it so much, and don't want you wet to change it. Typo. I love it just the way it is, and I love how it feels in my mouth. And then her response. What is that? Just about a minute and 21 seconds later. This is your pee, baby. So now we have San Diego. You heard testimony about this. It was brief. San Diego, she testified. This is the same thing. This is San Diego. Just raped Christy Mack. She tried to make me wait until after errands, as if. And those are the little emoji for eyes, and the P is sticking out the tongue, like, you know. And she testified, you know, he threw me over the bed and started, and, you know, I said no, but then I began to like it. It all plays into his reasonable belief in consent. It's not nice behavior. It's not nice behavior at all. But again, this goes back to the slide that discusses morality versus criminality. And with all of this, there is this reasonable belief in consent. And here it is. It's a defense to charge of sexual assault that the defendant, that the defendant entertain a reasonable and good faith belief that the alleged victim consented to engage in sexual intercourse. And look at the bold point. Even if mistaken. Even if mistaken. Reasonable inference. Christie sexually placating made John reasonably believe she consented. And you know it did. And you know it did. There's the rape fantasies, there's the choking. I hate standing up here and making these arguments, but this is the nature of this case. This is the evidence. That's who she was, and that's who he was. So now there's the sexual assault with a deadly weapon. This again really came in crystal clear through Detective Tamino, who made the charging decisions, was the DV or domestic violence investigator. Ms. McInerney tells Nurse Jerry that she was not penetrated. She tells Detective Lafreniere she was not penetrated. Yet, they all assume she was penetrated, even though Nurse Jerry describes the entry into the labial lips, and she still says she is not penetrated. Then she goes to the DA's office and has it explained to her again, weeks later, out of the hospital, that the legal standard is penetration, however slight. No recording, no notes, no nothing. She goes there. Joins the Secret Squirrel Society. You know, where you walk in with the defendant charged with 7 counts, and you walk out with 34. And you heard testimony from at least Detective Tamino, and then the state called a whole witness just to testify about, oh no, totally kosher, way above board. No. I mean, at that point, she's getting services. She's healing from her wounds. She's had the ability to appreciate how horrible this act was on her. And all of a sudden, it goes from no, he didn't penetrate my big lips, to, oh yeah, however slight, yeah. And that was her testimony. Yes, he slightly penetrated my my labia, my labia, I believe is what she said, or my lips. I don't remember. Pardon me, catching up again.
Counsel, how much more?
About 20 minutes. So now we have coercion, sex motivated. Christy had said, you know, he took away her phone 2 to 3 times in Las Vegas when she made threats to call either the police or her mother. Well, which 2 or 3 times? When? She didn't testify it synced up with the ferret cage incident or the snake water incident. She didn't testify she was going to call her mother on August 8th. So what? What? When? How? Where? I guess why? I don't know where these counts come from. I don't know what the specific conduct is, and I don't know the context of the conduct because it's not in evidence. And if it's not in evidence, it's not proven beyond a reasonable doubt. So, battery with a deadly weapon. Now you have the bull again. These are counts 21 through 23. Pardon me 1 sec. So these are the pokes to the ear. I'm sorry, the pokes to the ear, the arm or shoulder, and the hand wrist area. Okay. Make it easy. We're conceding these. These are batteries with a deadly. So that's counts 21 through 23. Counts 16 through 20, battery with substantial bodily harm. Again, he did it. He doesn't have a legal justification. These are not specific intent crimes. The voluntary intoxication, the mental defenses, the roid rage, the everything, the confluence of it all. Not a defense. Mark him guilty.
I'm so sorry. Can we approach real briefly?
If we must.
I'm sorry.
No, it's all.
All right, go ahead, Counsel.
Thank you. So, just so we know what we're talking about here, because I think it's a really big deal, what just happened. What we're talking about, count 16, fists to punch, face or the eye. Count 17, fist to punch, face or nose. So that's, okay, listen, maybe much ado about nothing. 2 counts, I suggest 2 hits, because I'm going to talk about the 2-hour beating, for which there is no evidence to support it. However, there's a great deal of evidence to support she was hit twice. Once in the cheek and once in the middle of the face. He's guilty. And it's horrible, and that's what those counts are. That all those pictures that have been shown all those times, and I need you, I really need you to separate these counts and keep them separate in your mind. They're different occasions, they're different counts. Because he did one does not mean he did the others. Please, please, please. For example, look, the snake counts. Here's the central problem with the snake counts. If you believe, and you may, I don't know, that he had the ability.
I'm sorry, counsel. Coming up.
Okay, sorry, 4 through 7.
No, just for.
Count 4 relates to that specific incident
4.
relating to the snake water. That's the way it's been worked.
Thank you. 34 counts, sometimes you lose your place. My bad. If you believe that Mr. Copenhaver could have grabbed Ms. Mack by the throat and brought her upstairs, and I get that the house is oddly laid out, and that's not necessarily, we don't really have evidence of that. That may not necessarily be so many steps like a regular flight, but still, if you believe that he can do that and bring her up, you have to ask yourself this: when? When in this time period? When from May 2013 to August 8th, 2014, did this happen? Because you have undisputed evidence that for several months, Mr. Copenhaver had a broken back. What if this supposedly occurred during that time? Which the allegation could be. Don't you have reasonable doubt at this point? That count should be not guilty. There's reasonable doubt. If there's no indication of when it occurred. Oh, we have testimony, he had the knee issue in December that took him out. So count 2 is coercion. Chrissy said that John almost always took her phone, but did not specify that in this instance, he took her phone. Not proven. Not proven. Not beyond a reasonable doubt. Not guilty. So, count 1 then, if I finally understand correctly, count 1 is what we've referred to as the ferret incident. Sometimes perhaps the laundry room incident, where there was a dispute over a ferret cage and Mr. Copenhaver was supposed to have removed her to the laundry room via the same thing, picking her up. And then there was testimony about some strangulation in the laundry room. Again, here's the problem with it. She says this happened early July. Now, they weren't together, they hadn't seen each other until after she got back from San Francisco, which is July 18th and 19th? And then she's in San Diego, I think July like 20, well, John comes to Las Vegas like the 23rd to the 25th or something. Then like 2 days later, Christy comes to San Diego, and then John comes back to Las Vegas, like, I think like the 1st through the 4th, because unless the 4th was that Monday that Ms. McInday talked to Mr. Thomas, in which case to the 3rd. How did this happen in early July? Because it didn't. It's not proven. That's certainly not proven beyond a reasonable doubt. He hadn't seen her in that time period. The evidence is clear. Then you have the dissuading. It didn't happen. It didn't happen. He wasn't there in early July. So this is wrong. The ferret is count 1. And again, forgive the blank nature of that. The coercion in that situation, based on the evidence given, was not proven. Not to mention, the date doesn't sync. If you go back and look at your notes, there's no evidence of coercion on that series of events. So I think we just went through this. This is the snake. Again, on the coercion, I'm sorry, may I have a second? I lost my place again. That's what I thought. Okay, thank you. All right. Now, these are the two that are standalones. Coercion, instructing not to report, is the general testimony. He would always take my phone, and it happened 2 to 3 times in Las Vegas. You still have to agree on what event, and you have no more evidence than that. Not proven, not guilty. So that one's as simple as that. And likewise with the, okay, I guess I've skipped the dissuading. And likewise with that. You just don't have the evidence upon which to base that verdict. So now here's the Boulevard Mall incident. Dr. Sachs testified about the dashboards being smooth unless there's an object, and unfortunately this is the only picture we have, and I'll get into that in a second, as delicately as I can. But isn't it unlikely that someone hits this face first and doesn't break their nose or something before they chip a little bit of their tooth? That's, to me, that's common sense. You're the judges of the facts. So, actually, before we get to that, I want to go through a couple of things. Ms. McInday testified this happened in February or March. And we have a picture of the tooth being sent to a dentist on February 7th, which could be, by the way, a month before she said the incident happened. There's an ambiguity. There's some not guilty. However, I want to go through these. This is the snake picture around the neck that you just saw, February 1st. This is John at War Machine 170's Twitter, February 4th, going after a company called Fleshlight. You heard some evidence that without, I don't think anyone, unless you know it independently, in which case don't bring your independent knowledge into the jury room. But so we don't know what Fleshlight is, but we know that she had a contract and he's going after them saying, attention, they're ripping you off. If this happened a couple days before February 7th, on February 5th, she's sending him a picture of this is the picture of the snake around her legs, February 5th. This is him sending back his legs. I guess in some relationships, you take selfies of your legs and text them back and forth. Here's another one of his leg. He's got a bruise.
Counsel, which numbers are those? All right, keep going. Keep going.
Thank you. All right, now here's February 7th. And here's how we know this is the day that he went to the dentist. We have no idea what day this happened, but we know he went to the dentist on February 7th because we have in evidence the Instagram post, got fitted for a new mouth guard at Guard Ya Grill. And they gave him Girl Scout cookies. I think we went through this yesterday. He's eating a Girl Scout cookie with his I Heart Girl Scout cookies pin on his shoulder. Now here's her on February 8th. No damage, sending him a selfie. Oh, see that? Nothing shocking. Here's February 9th. This is this just shows the date from Twitter. And John saying, lol, who does makeup like this? At Christy Mack, and then the picture. And here's the picture of her up on the counter with the snake over her shoulder doing makeup. Who does do makeup like that? She's a wonderful free spirit, and that's great. But nonetheless, this was taken on February 9th, showing more of that timeline. February 11th, John's going on the Joe Rogan show in Los Angeles. It's just an Instagram post showing that timeline. And then, here you go, this picture in the Prius again, which, if it happened before the chipped tooth, would have been a couple days before February 7th. And, here's the car, here's the scene of the crime, and here's a favor being done for Mr. Copenhaver. It's a timeline, and it's, we see this, and the only explanation is this abstract domestic violence, I don't know, pattern, syndrome, what have you. And that's the only way to tie it together. And you heard that witness. And that witness didn't hold up under cross-examination. So,
Sorry, counsel, I apologize for interrupting. It appears that only counts 7 and 8 relate to the Boulevard Mall, and 9 through 12 relate to the Houston incident. So the slide that shows 7 to 12 is incorrect. Keep going. And it's 5 to 4.
I'm working on it. All right, in terms of, she could tell he was going to do something wrong in the battery incident. Take a look at which crimes are specific and general, and take a look at which crime. I'm just going to try to speed through this. The kidnapping, she supposedly gets out of the car in traffic, no one calls. She's yanked back into a car at a stop. No one calls the police, no one. And she testified there was traffic there. Now we go to the Houston incident. So we know she returned on February 7th from Aaron McAday's testimony. That was the day that the snake died. Did I say February 7th? I meant May 7th, if I said that. There were 4 to 5 people home. Aaron McAday, Chad Collins, Christy McAday, John, and another person named Barry Dooley. 2 days later, they're out at Benihana's. And then he sends, I think it's an Instagram post of the snake dying before he calls her. She's rightfully upset. He's cut the belly of the snake open and tried to save the babies. It didn't work. So let's talk about the sexual assaults, 9, 10, 11, and 12. Sexual assault, hand or finger. Sexual assault, sexual intercourse. Attempted sexual assault, anal intercourse. On the attempt, in addition to the reasonable belief in consent defense, you can consider voluntary intoxication. And on sexual assault, this is the sexual intercourse. So vaginal sex, attempted anal sex, and then flipping back around, vaginal sex. Rape fantasy, reasonable belief in consent. Like it or not, and I would bet most of you don't, he can do these things, he believes he can do these things based upon the conduct, based upon the language of this relationship, based upon the way things have progressed. How do we know this? What does he say to her afterwards? Why are you crying? Well, why is she crying? Because she feels she's just been raped. Why does he ask? Why are you crying? He doesn't understand why this isn't okay. I think we went over this. Oh, no, but this is important for the Houston counts. When asked in the hospital, and then, have you ever been the victim of sexual assault in the past? No. No. Again, meeting with the Secret Squirrel Society, and there we go. 27 more counts. Okay. Corey Thomas. "27. The 5 punches to the face, and then the about 20 before Corey Thomas gains control. So this is 27, 28, and 29. Guilty. Why is everybody writing that down? Now we have 30, 31, 32. Battery by strangulation. Okay, you just wrote guilty for count 29, which means what? It was a seat belt under the arm. That's how he dislocated the shoulder. under the arm. As hard as Herman Tirado tried, it wasn't going to choke Mr. Stewart to death. His testimony was clear. You can't choke someone like that. It's not a battery by strangulation. And by the way, that lasted, it was never an impediment to air. The details of that one are really sketchy. Because, I mean, likely because Mr. Thomas, just had counts 27, 28, and 29 performed on it. Hits to the face and you bite of the face. I get it, but there's still not enough evidence to get you to a battery by strangulation. This is count 30, the original seatbelt. And he's able to flip John off, head into the end table, which breaks the end table with the mysterious pills on it, and then up into the wall with the head smashed against the wall. Second one, John gets him into what's called a rear naked choke. There he could kill him if he wants. And he didn't do it because he wanted to ask him questions. And you can hear it on the phone on the 911 call that he starts asking him questions fairly early in. That's why Corey Thomas was able to get hands up in there, because this wasn't a full rear naked choke. And then the third one is the seatbelt, because that's an interrogation. What are you doing here? Christy, tell him you love me. We were going to get married. All right. Then you have 33. So we talked about the seatbelt, the rear naked choke, the seatbelt. The purpose was to ask questions and to never have him come around again. What did Corey Thomas on his own testify to about these holds? He didn't do a ton of Brazilian Jiu-Jitsu, but 100 classes over 2 years, pretty decent, plus the wrestling training. What are these? They're for submission. They're for submission. So, this goes to all witnesses. I'm not suggesting Mr. Thomas lied, but this is a real critic. I'm by the way, just finishing up here. So these are jury instructions. If you believe a witness lied about any material fact, you may disregard the entire testimony. I would submit to you, if you think the witness is mistaken about any fact, doesn't have clear memory, is backfilling, you may disregard the entire testimony. So, we talked about this sort of what became a power couple. The only way Ms. McInday knew the fights that she had been to was by the colors of her dresses, black, white, and red. Here we go. Valentine's Day, he's in the cage, she's cage side, blowing him a kiss. There's another picture of her in the red dress, who's got the fighting gloves on, and they're holding hands. This is who they were. This is who they were. I hate having to say this, but I do. Her testimony, and I get it, it's 2.5 years later, read like the domestic violence expert's testimony, the cycle of, these were the best days of our relationship, for example, after an incident. With love and respect. Do you see this guy running out and getting Starbucks for someone? No. He trains every day, all day long. He's not staying home doting on her, running to Starbucks, taking care of the dogs, taking care of the snakes. Not that he didn't do those things, but this was trying to create a cycle that wasn't there. Oh, let me go back a second. There's a lot of testimony about the alpha male shit. Remember, Ms. McInday testified that that was their line. She helped them create it. So here are the some of the inconsistencies with Ms. McInday's testimony. The dogs are gentle and playful, but they bit a neighbor. Cleo tried to bite John. Dogs had to be controlled before the police can go in the house. Day one of her testimony, she testified about rules and guidelines for a rape fantasy, but on cross, she didn't recall testifying to rules and guidelines. She had prior testified that they were through text and now wasn't sure. She said that earlier I brought her testimony. When we say PX, we mean preliminary hearing. Choking unconscious was not part of the rape fantasy. And at trial, there was an agreement that 3 times consensually John choked her unconscious. We talked about corset sweatpants. She said shorts. Here was maybe one of the more important things of the trial that were very small. And I talked to you about this during opening. There are a lot of little things, but Officer Truax drives up and down the street, or I believe it was the other officer, who was formerly Officer Schumacher, Shepard, thank you, was driving up and down the street, windows open, went to the neighbor, and you saw pictures of how close the neighbor was. They're not hearing anything. They're not hearing anything. You saw the sliders on the back door. Those sliders aren't the greatest in terms of noise deafening. If you've ever been through one of them or had one of them, you know that. Not hearing anything. Meaning it gets calm. They stay on the scene till 2:30. Goes back and he testifies. So you're not allowed to bring your experiences into the jury room. For example, if you're well trained in computers, we have this evidence about Google Plus, and you can't, you have to take what testimony there is. And so we heard testimony, Christy, it's total and normal childhood, graduated from high school, nightly shoe outlet, straight to fetish video, and then porn. This is not a normal cycle of events for someone that had been doing porn for a while and was 22 when this happened. No motion to have her evaluated. We don't know. Other than the text to Corey Thomas, we don't know really what's going on with her. Why she strives for this very unique identity. The mohawk, the tattoo, the purple wigs, the gold grill, all of that. All right, Mr. Copenhaver is entitled to your individual opinion. I'm not going to belabor this because we talked about it in jury selection, but this is the student in Tiananmen Square in China, standing in defiance of these tanks. Deliberate, talk to each other, see if you can come to a verdict. But after, if you're firmly convinced in your position, hold out like this person. All persons stand equal before the law and to be treated as equals. In this case, you may not like it, but there are a lot of counts that go not guilty. So what is an abiding conviction of the truth of the charge?
This would be quantified reasonable doubt.
Right. I've defined it for them. It's time to
finished. I don't get up again. I don't get to make a second argument. The state does. I would ask you to consider the points I've raised and independently think about the evidence. I may have missed something. 12 heads are better than one. Ultimately, whether Mr. Copenhaver is guilty or innocent of each and every count, I'm sorry, guilty or not guilty, this is not about innocence, rests heavily upon all of your shoulders. This is no easy task. This is one of the hardest things you do as a citizen. I can't make any more arguments. But I ask you to think about both sides when you get back there. I thank you for your time. I'm sorry I went so long.